Hello and welcome to our webinar, GDPR, a transatlantic review of data privacy. It's brought to you by the European American Chamber of Commerce, Southwest France. My name is Nick Abadjian. I am with the Southwest chapter in France here in Toulouse. We welcome your questions both in English and French. Just drop a question in the chat, please. Today's presentation will look at GDPR 2 years after the European Union launched it. Even today, companies that prepared for it are wondering if they are still compliant. This presentation looks at the impact that privacy laws are having on digital platforms and the legal issues on both sides of the Atlantic. We have two experts with us today that will give a legal take on GDPR and also a UX perspective. On the legal side is Greg Voss. He's a resident faculty member at TBS School where he teaches business law. He holds a Juris Doctor from the University of Michigan and a DESS in Law and Information Systems from the University of Toulouse. He's also an associate member of the Research Institute in European International and Comparative Law at the University of Toulouse as well. His most recent publication is Cross-Border Data Flows, the GDPR and Data Governments, which was published in the Washington International Law Journal. On the UX side, we have Alex McArdle, who will show us real case scenarios with international websites. He's actually in Vietnam right now, and it should be close to bedtime for him.
I'm already asleep now.
Thanks a lot. Alex is an international digital strategist. He is the founder and CEO of WS Interactive, a Toulouse-based agency that is passionate about digital strategy, UI, UX design, and web development. And I should mention that Alex is also a co-president of the EACC in Southwest France. I would like to thank Digital 13. They had hosted our event. Originally, it was supposed to be an in-person event. Due to the pandemic, we decided to transform it into a webinar. Without further ado, I give the floor to Greg Voss.
Thank you very much, Nick. I'm going to put up my PowerPoint presentation, but thank you for the introduction, very complete. I don't think I have anything to add to that, except for a typical disclosure, and that is that obviously today's presentation, I'm a business law professor at TBS Business School here in Toulouse. Today's presentation does not constitute legal advice. So that's the typical lawyer's disclaimer here. So let me put on my PowerPoint and let's get us started with the GDPR. Okay, let me just show you the lay of the land, if I will. And that is what I intend to cover in this short period that we have today. And as you can see, it's a relative lot, but I'm just going to say a little about each. And if I need to develop things more, we can do that during the question and answer session. So first, I'm going to contrast the EU data protection framework with the US data protection or data privacy law. Then I'm going to talk briefly about data protection principles and their origins. Next, I'm going to show just the test you go through to see if GDPR applies or not. Following that, I'll talk generally about the change we've got in France since the Loi Informatique et Liberté in 1978 and the GDPR 40 years after. I'll identify the actors of the data processing environment. I'll talk about transatlantic data transfers, which, since we're in a European American Chamber of Commerce setting, I think is important. And then I'm going to talk about a recent case. And next, I will talk about new, under the GDPR, data subject rights and GDPR sanctions generally. Briefly, I'll discuss compliance efforts and finally, certain issues regarding certain new technologies. So let's get started. Okay, as a first starting point to contrast EU data protection law and US data privacy law, if we look at the European Union, in the European Union, we have, through the European Convention on Human Rights, recognizing the right to privacy, and in the Charter of Fundamental Rights of the European Union, which became a more central part of European Union law with the passage of the Treaty of Lisbon in 2009. We have not only privacy, but also data protection becoming a fundamental right in the European Union. And when I say fundamental right, I mean a right that's considered inalienable, that's of a more or less constitutional level. It's not absolute. It will be balanced against other fundamental rights, for example, the right of freedom of expression or the right to information. In the US, on the other hand, the Constitution doesn't mention privacy, excuse me, much less data protection. Although there are certain state constitutions that do mention it. In the United States, most discussion of privacy has been in connection with the government, that is privacy from the government, for example, under Amendment 4 to the US Constitution. In the European Union, there is omnibus data privacy law. In other words, it's data privacy law that applies generally regardless of the economic sector involved. We can contrast that with the United States, where in the United States, there are certain sectoral laws, like the Fair Credit Reporting Act in the area of credit reports, or with respect to other financial data, the Gramm-Leach-Bliley Act, or with respect to health data, HIPAA, or children's data, COPA. Each of these has very limited scope. For example, HIPAA concerns certain actors defined in the statute. Although we may find that internet players like Google are playing a role with respect to health data. They're not caught up by HIPAA. In addition, these sectoral laws don't cover all sectors of the economy. For example, in the area of tech law and the big tech companies, most of the activities of the tech giants aren't caught by these sectoral laws. So we see that there's a very different coverage between the United States and the European Union, and a very different basis. Let me just go back, if I can, to this slide. We could add, in the last category on the right, in the bottom right, there are also state laws that are coming up. For example, with the lack of a US federal law, general US federal law, we have certain states adopting legislation to a certain extent inspired by the European law, by the GDPR. For example, we have the CCPA in California, and I've seen it discussed recently. I saw a new draft bill in Washington State, where they're considering legislation somewhat along the lines of the CCPA. Now, when I look at data privacy, data protection, there are principles that are behind it. Today, we find those in the GDPR as the GDPR data protection principles. However, if we look a little historically, these principles were early principles recognized by the United States as well, because they were developed in the United States under the HEW report, where they were called the Fair Information Practice Principles, the FIPS. The FIPS included a data quality principle. Data had to be correct or amended, had to be reliable for their intended use. There had to be a purpose for the collection and the processing. Their use was limited to that purpose. There were security safeguards set up. There was a certain level of transparency about this processing, and there were rights of the data subject. If we look at the far right column in the GDPR, these have been translated and developed further. We have the data quality concept, or the principle, which means that data should be accurate. There should be a minimization of the data collected and processed. There is a limited storage period for the data. And then in terms of purpose, there is a purpose limitation, which includes both the concept of you needing to specify the purpose for which the data are collected and used, and the use should be limited to that. Next, the GDPR refers to integrity and confidentiality, which corresponds to the earlier security safeguards. Transparency is an explicit GDPR data protection principle. And we see that there are rights of the data subject, the person to whom the data relates, and these have been developed further in the GDPR than in earlier European Union legislation. Furthermore, there's a requirement that in order to have the processing of what the Europeans call personal data, there must be a lawful basis, a legitimate basis under the GDPR for that processing. And the processing must be carried out in a fair manner. Now, if we look at this chart, we see also two other instruments discussed. One is the OECD guidelines, which are just what they say, guidelines. They're not requirements, they're recommendations. These have been influential in the development of the internet and have been discussed in the United States by the FTC. They have been modernized more recently. But as you know, the United States participates in the OECD and has referred to these guidelines in data privacy law. Now, some of these guidelines have been picked up, or some of these FIPS have been picked up in US legislation. But there's not a complete consistency in the sectoral law in the United States in picking up these guidelines. The middle category, or the third column, Convention 108, is the only compulsory or mandatory international convention. In other words, this is a convention that nations can sign up to. And when they sign up to, they agree to provide legislation protections of these different principles. This convention has recently been modernized to make it compatible with the provisions of the GDPR. And today we see the European Union encouraging nations outside of Europe to sign on to Convention 108. Convention 108 was sponsored by the Council of Europe, which includes the European Union nations, but also nations from outside of the European Union, like Turkey, Russia, and so on. But today, Convention 108 has members from Africa, from South America, from Asia that have signed up as well. And Europe has suggested to the United States that it would be a good idea for the United States to sign up to Convention 108 modernized, or 108 plus. But the United States hasn't done this yet. Now, if we're looking at the GDPR itself and how to analyze whether it applies to a company or not, first of all, we look to see whether personal data has been collected. And when we're talking about personal data in this context, we're talking about the personal data of persons in the European Union. They don't have to be European Union citizens, but they have to be people present in the European Union. Now, the definition of personal data is a broad one. It relates to information about identifiable or identified natural persons, individuals like you and me. And also, we take a look and see if data have been properly anonymized. Because if data have been properly anonymized, made anonymous, they fall outside of the definition of personal data. Next, there's a separate category of personal data which gets special attention. That category are what we call special categories of data, which I will sometimes refer to as sensitive data. These can be data about political opinions. They can be related to religion, related to health, and so on. These are areas where the general rule is they should not be processed. However, in certain circumstances, they can be processed, but the restrictions are greater. Now, if we have personal data collected, then we have to look and see, does the GDPR apply? It applies if the territorial and the material tests are met. And these include whether an establishment, whether the processing is related to an establishment in the European Union, or whether it's related to an offer of goods or services to EU residents, even if the person processing that data does not have a European Union establishment. It can also apply to non-EU data controllers if they're monitoring behavior, where that behavior is taking place in the European Union. Next, if we find that the GDPR applies, we have to see whether or not there's a legal basis for processing those data. The perhaps most characteristic legal basis is data subject consent. However, there are other legal bases. For example, is the data processing necessary for a contract? Is the data processing necessary for compliance with a legal obligation? Is data processing necessary to protect the vital interests of a natural person? Is data processing necessary for public interest tasks, or is it necessary for a controller's legitimate interests? However, this is a limited basis because there's a balancing of the legitimate interests of the data controller against the rights to the fundamental rights protection, the data protection of the data subject. Where consent is the basis for the processing, it must be freely given, specific, and informed. That is, information has to be given to the person, and it has to be unambiguous. Now, just quickly here, accountability refers to the concept that someone has to be responsible for data protection compliance. there are no longer administrative formalities to be complied with before processing. However, a data controller or a data processor has to be able to prove compliance with data protection law at all times. And we have higher fines for violation. Now, there are different tools that have been set up to help compliance. For example, the requirement of a processing register for many companies, with some exclusion for small and medium-sized enterprises. Other tools that may be required include a data protection impact assessment or having a data protection officer. In addition, codes of good conduct and certification may be tools to help compliance. Furthermore, there's an incentive to comply with the law as efforts taken to comply are included in the assessment of sanctions. Now, if we look at the actors of the data processing environment, we've already mentioned the main actors. The data subject is the natural person to whom the personal data relate. The data controller is the party that actually is determining what data will be collected, what are the means that are going to be used for the processing, what are the purposes of the processing, and so on. There could be more than one data controller. There could be a joint controller. Now, the controller may call upon a data processor to actually handle the processing of the data. While most of the responsibilities for data protection compliance are with the data controller, some are with the processor. Finally, we could have additional data processors or sub-processors. Now, given that we're in a European American context here, I want to talk about data transfers. In 1995, European Union law added a restriction on cross-border data transfers outside of the European Union to countries where they didn't offer an adequate level of protection of personal data. The US never got a formal evaluation, but it's generally considered that the US is a third-party nation, which does not ensure an adequate level of privacy protection. So this would have resulted in a restriction of data transfers from the European Union to the United States. So Europe and the US, the Department of Commerce and the European Commission negotiated a safe harbor framework to allow for data transfers, which involved companies self-certifying that they complied with the principles of this framework, which were more or less equivalent to giving the rights of European Union law to data subjects. There were also instruments that were developed which involved binding corporate rules, which could be adhered to by members of the same corporate group, and they were binding. They could be litigated if they were not complied with. And standard contract clauses, which were developed by the European Commission, which are clauses that can be inserted, say, into a contract between the data controller in the European Union and a data processor in another country to allow for the transfer of data to that other country, even if they're not considered to have an adequate level of protection. That's because the SCCs, the standard contractual clauses, allow protections that are more or less equivalent to protections in the European Union. And they provide that the data subject will enjoy third-party beneficiary rights. In other words, they can act against the parties if they're not complying with the standard contractual clauses. Now, this safe harbor was challenged after it became known that we had mass surveillance in the United States through the disclosure of Edward Snowden in a case called Schrems 1, where Maximilian Schrems, who is still active today as a data protection activist, but at the time he was an Austrian law student who used Facebook and had his data transferred by Facebook to the United States under the safe harbor. He argued that his data wasn't getting equivalent protection because US authorities could access his data through mass surveillance. So the safe harbor was invalidated in a European Court of Justice case. Now, in the interim, we have the GDPR being adopted, and the United States and the European Union negotiated the Privacy Shield, a framework which replaced the safe harbor. It added some additional protections and allowed for some recourse of European Union data subjects by going to an ombudsman who was appointed under the Privacy Shield. It also provided for the accountability of different parties for onward transfers from the United States to another country, for example. There were 3 annual reviews of the Privacy Shield, and the European Commission, who conducted these reviews in cooperation with the United States authorities, found that generally speaking, the Privacy Shield was running well. However, each time there was some shortfalls that were pointed out, and the US was supposed to act on these. In 2018, we had the GDPR becoming applicable after a 2-year transition period. And then in this summer, in July of this year, we have the decision of Schrems 2, which involved an invalidation of the Privacy Shield by the European Court of Justice, the highest European Union court, on bases that still relate to US mass surveillance. So we could say that US mass surveillance is the elephant in the room, the thing that is present there that we're not talking about when we talk about data privacy law. But in terms of these cross-Atlantic transfers, they're very important. So the result of the Schrems 2 case was companies can no longer use this Privacy Shield as a basis, an adequate protection, adequate safeguard to transfer data to the United States. However, standard contractual clauses can still be used subject to conditions. And those conditions involve an assessment of whether an adequate or equivalent level of protection can still be obtained in using the SCC in transferring the data to the third country. This may be involving a legal analysis of the laws of that third country. So we're getting to a concept that I highlighted in my article that Nick mentioned, my article in the Washington International Law Journal. And that concept is more and more data controllers can be seen to have responsibilities for the personal data environment, their ecosystem. That is, there's a requirement of doing a certain amount of investigation when these transfers occur. And furthermore, in the concept of these SCCs, there may be a requirement of additional protections being taken with respect to transfers to the United States. For example, a German data protection authority suggested that with respect to transfer to the United States, encryption should be used, pseudonymization should be used, and so on. So we have some additional requirements that may be applicable. Next, let me just mention briefly, I know I'm going sort of over my time, but let me mention briefly the new data subject rights. And I'm sure in the questions we'll go into this further. First is a new right to data portability, a right to obtain data from data controllers in a format that allows transmitting it into another system easily. Next, there's a right to erasure, a right to be forgotten when data no longer are needed for the purposes for which they're collected, or where consent is withdrawn, where that's the basis for the collection and the processing. Excuse me. There are two categories of violations. The higher, the more severe category, we have potentially for companies up to 4% of total worldwide annual turnover being a potential fine. The greater of that, or 20 million euros. Next, if we look at the concept of compliance, complying with a higher level may, such as the GDPR worldwide, this is something I see Microsoft taking on board, for example, may help a company prepare for new legislation upcoming, either on the international level or on the US state level. For example, the CCPA in the United States. Also, we see that this concept of compliance measures helping in the event of a data protection violation, it's important because the data protection authorities are supposed to take into consideration action taken to lessen damage, cooperation with the data protection authorities, how the infringement became known to them. It's better to report the infringement to them yourselves. And what is the number of data subjects affected, the level of damage, and so on will be taken into consideration. Furthermore, there's a new one-stop shop mechanism which has been established where there will be one data protection authority who will be considered the lead authority with whom the data controller will deal. And I believe this is my final text slide. And that is, there are certain issues that are involved with certain new technologies. For example, in the concept of big data or data analytics, one way to easily allow for big data usages is to properly anonymize data. But properly anonymizing data is difficult because with the development of greater computing power, it becomes easier and easier to re-identify data. So we have in the European Union some tests that have been set out by the predecessor to the European Data Protection Board, which allows you to analyze anonymization techniques to see how effective they are. And next, transparency principles and data minimization requirements tend to go against the tendency of big data analysis to want to keep their algorithm secret, they want to keep their processes as secret as possible, and they want to collect as much data as possible. So there's some tension there. Furthermore, there's tension with the purpose limitation principle, because with big data, sometimes the purpose for the future processing isn't known until correlations can be found, which causes problems, which may be remedied if we keep big data analysis on the level of statistical analysis and not on the individual level itself. Next, if we look at smart contracts and blockchains, there are several problems that present themselves. For example, allowing for the right to erasure or the right to be forgotten, where actually part of the purpose of the blockchain is to have the blockchain reproduced many times so that you can protect its integrity, so that it doesn't disappear. Furthermore, there's tension in the concept of permissionless or public blockchains, and it seems that in the context of the GDPR, it's more likely to find a blockchain compatible or smart contract compatible with the GDPR if it's a permissioned private blockchain containing non-personal data rather than a permissionless public blockchain. Okay, those are just some key points I wanted to make, but I'm sure more points will come out in the questions. So thank you very much for your attention. And I hand over the microphone to Alex.
Yes. All right.
Hold on, let me just see if I can give you back.
I got it.
Oh, you've got it. Thank you.
Okay. Thank you, Greg, for that nice discussion and giving us a legal framework with which to work. I'm going to talk about the reality of how we can maintain that compliance and probably bring it down a little bit to more small business and just get in depth on the user experience side of what's happening with the GDPR and how it impacts your digital platform. So I'm Alex McCardle, and I want to thank Nick for introducing me earlier. I am director of WS Interactive, and I've been working with the web and digital since for over 20 years. And so GDPR has become a big part of that since before 2018. But since 2018, it impacted a lot of our business, a lot of our customers who were actually, there was, I wouldn't say panic, but it was, you know, when you see those hefty fines that are applied to the big companies as well as to the small companies, you know, you begin to wonder, are you doing what you need to be doing? So what is it really? And I hope we can maybe relativize a little bit the situation. And as I am not a lawyer either, so I will not give any, I don't know that, I won't give any legal advice, but I will give user experience advice that you are free to use. But actually, if we put the user at the heart of our work, we find that actually maintaining compliance doesn't have to be so obscure and dangerous. So we'll talk about the cookies and what it means to the consent, what's going on, and then what that impact is on your user experience, what kind of data we're collecting, and going into the analytics and anonymity that Greg touched on is definitely something that we should all be aware of. And real quickly on the right to delete, as I call it, and your privacy policy. So I'm not going to try to repeat anything Greg laid out in terms of definitions, but it really does apply to anyone doing business within the European Union for the GDPR, okay? So if you are not in the European Union, but you're doing business to people within the European Union, then you must be compliant. So if there's a website outside, like in America, and you do collect users, data from users inside the EU, you need to make sure you're up to speed. And the same with the CCPA, but with California. And for the CCPA, the biggest difference there is that it only applies to for-profit businesses that are collecting California resident personal information and that have a revenue of a certain threshold, or if they disclose a certain amount of personal information, or if they make a certain percentage of revenue, et cetera. So it's a little less constricting to small businesses, whereas the GDPR really is impacting everyone doing business. So let's talk about consent user experience, because if you get consent from the user, then you are not breaching any data privacy issues. But getting consent from the user has turned out to be quite a challenge in certain situations. So let's look at the ground rules for our cookies. And for those who don't know what cookies are, they are coded instructions that are going to be stored on your computer when you visit a website. And historically, they were used to track your navigation and maybe offer you a certain ease of use to guide you through other navigating options, or remember a little bit about what you saw last time. As we've gone throughout the years, they have been able to become quite well known for knowing more about you than you know about yourself in some cases. So under the GDPR, website owners, so the customers running the website and their operators, so web agencies or any type of operator, are both legally responsible. And that's an important issue when you're putting together a digital platform, a website, or any of that kind of business. It is a collaborative effort, and agencies are there to help as much as possible. Further, just a couple details. You have to be 16 years old to grant consent, so that could have an impact on those who have services going out to minors. And whereas in the UK, it is 13 years old. In 2021, Apple, for apps, anybody having an app are also must be GDPR compliant, and they will require developers to obtain consent prior to tracking any users. Right now, it's an optional issue, and I would imagine Apple is protecting itself in this situation as an operator. And also be careful of third-party tools. And actually, from 2018 to today, the big deal was, are we compliant? Are our cookies, are we tracking personal information? But what's happened is that third-party, you'll see more and more cookies that have access that embed other cookies. And then there's this long trail of cookies actually that you might not even be aware of. So if you put on a Google map or a CAPTCHA, we can identify that. But beyond that, there might be other cookies. Actually, there is a current case with Salesforce for having some third-party cookies that were not compliant. And there is a lawsuit out. I believe it's a class action lawsuit, international, because of that. And so if you're a small business owner and you've got some kind of Salesforce API going on with a cookie, you may want to, you are responsible to know where that leads. Where is the finality of the data going? And a really big issue occurred in June of this year. So in 2018, when GDPR was applied, there was a bit of a vague notion of what is consent. So when you, very classical, arrived on a website, I've left this in French because coming from the CNIL, but basically, when you got to a website, what was consent was if you scrolled on the page, if you decided to click a link, could be considered consent. And in any case, in the legal framework of the GDPR, it was a bit vague. So in 2020, before 2020, they said, okay, now scrolling a page, navigating a website does not constitute consent. It is not an positive action. So today, as of this moment, if you still have that old, so a lot of cookie banners, we'll call them, allowed for this to happen because of the tracking the data. We wanted to measure our traffic. So as soon as somebody scrolled, we would activate the cookie. And since June 2020, that is no longer applicable, and there are still quite a lot of websites that have not been updated. So let's look at our obligations, and I'll take a look at a few best practices or not so good practices. We have to be able to read all the content. The user must, when they come onto the site, be able to access that content without consenting. So no forced pop-up is allowed. You can have a zone dedicated to the act of consenting, but that should not block them from reading it. You also need to allow the user to modify their choice at any time, and it has to be clearly accessible. And so you cannot trace the user until they have explicitly said yes. So that's a big impact on the user experience right away, because we cannot trace them thoroughly if they haven't consented. And then finally, it has to be renewed every 13 months. Now, fortunately, the technical components that go into getting consent have become quite banal and pretty easy to implement, but still they require a certain thought and a certain reflection on what you want to do with your web platform. So let's look at a couple of examples. So here, these are very recent examples after June of 2020. So if you see this in this policy here, it says, by continuing to browse the site, you are agreeing to accept our use of cookies. That's wrong right away. That is not compliant with GDPR. Here's another example. Météo France, big company, you get on there and it blocks you with this pop-up. I have to either click accept it and close it, or en savoir plus, to know more, which is not exactly personalizing if I want to configure the consentment I'm willing to give. So there's an issue here. I cannot get out of this banner without making a choice. Another similar example here, the text is just grayed out and I can scroll it. It's kind of, yes, I can read it, but no, I can't. I have to authorize all these cookies so I can read the site. This is not GDPR compliant today. Another couple examples, Lagardère, big company, very small print, and somewhere down there it says, if you navigate this site, then you accept to use our cookies. So here's I click and that has magically disappeared, and they have determined that I accept fully the cookie. So from June of 2018 to June of 2020, this was considered, was tolerated by the GDPR, and it is tolerated no more. So please be careful of that. Sorry, let me just, I think I get out of that. So here is something that we do, and something we've studied very thoroughly about how we can have the user experience, and we look to personalize the cookie banner, very simple, and where the user can scroll the website, and on a mobile as well. It is a little bit distractive. You do have to sort of make a choice. We can sort of encourage that kind of behavior, but it's still, we haven't blocked any access to the content. And our own website, we went a little bit further, and we would personalize it to be a part of the website, so that the user experience was not going to be threatened by some ugly banner that had no sense to be on our website. So you can do some things to make the user experience a little bit better. And of course, and we'll talk about analytics in a little bit, because that was the big fear, is if people don't accept the cookie, then they're not being measured as audience. And we have some solutions for that I'll get into a little later. Also, once you have that, the warning or whatever the banner, we'll call it, that lets people know, gets people aware, the user is aware that they have to accept these cookies, but they can go personalize. And there are really simple tools. There's no need to be too creative on this. This is something we use with Tarte Citron. There are many other tools. This is very simple, but you cover the three major aspects, which are each third party, each cookie, even third party cookies, has to be recognized with a link to the information, the details of what data is being tracked and where that data is going, and then just to either allow it or to deny. That's as simple as that. It can get a little bit more detailed. Here's the Guardian. Again, this one sort of tool that's going to automatize a lot of this, but you could have hundreds of cookies listed here, and you can go and see each feature. You can turn on and off different ones. So, you know, and this is becoming more and more acceptable in the user world. You know, where they can turn on and off at a whim what they want. Another one from Le Monde, which is really categorizing types of cookies. So there are certain cookies that are necessary, but then there's the analytics tracking cookies that you can turn off, or social media cookies, or any kind of personalization. Advertising cookies, of course, can be turned on and off. So this is giving the user a little bit more control. And like I said at the beginning, when you put the user really at the heart of what you're doing, we can start to see the benefits of GDPR. And I will be upfront and honest, and I thought GDPR might be a little bit rough on especially small businesses, comparing the data simple form of getting information from users as intrusive, comparing that to what maybe a Google or a Facebook is doing. It's not easy to make that connection, but in the end, the user can benefit from controlling, and the company does not lose out on that. Thinking of those bigger players, what are they doing? And I think this is, again, going back to the user and the benefits, is really they're turning the strategy around and the approach around to say, hey, listen, you want to use our services? Well, we're going to have cookies, but these cookies are going to deliver you personalized content, personalized ads that you're going to like. And if you don't accept these, you'll just get terrible ads that you don't like, but you're still going to get the ads. And I think what Twitter was doing was really just spelling that out very clearly. Twitter will personalize the ads, and if you want to learn more, learn more. But these ads are bringing you useful and interesting advertising and different content that is based on your interest. And if you don't want us to show you those interesting ads, turn it off and you'll get all the ads that you don't care about. So, and I think that obviously it can be daring if people aren't interested in what you're offering, but if they want to use your service, there's a trade-off. And I think it's becoming an acceptable trade-off. And so the user experience just needs to be just flow. There's enough historical data now to say that we can do things correctly without endangering our analytics or endangering our image. So the rule of thumb is what? Let's be elegant, let's be visible, but let's not be too distractive or too small that we don't see it. Let's blend it in with the color schemes of our website, and let's encourage the user to accept. We do want them to just get on with it and accept, but you have to allow them the opportunity to deny and to filter out the different cookies that you're using. So obviously it's a very brief overview of that, but I think you can get a good point of what's happening over the last couple of years. And then there's the collecting data, how you collect data. So Greg touched on that briefly earlier. What is personal identifiable information? So GDPR defines it among a certain number of criteria. I highlighted the online identifier. That's for us, the IP address. That's going to be the first thing that we're getting. You can go onto these sources, the GDPR.eu or even the European Union, and just read up on it. But basically, that IP address is the first thing we're going to get. And with the CCPA, same thing, IP address. But you'll see if you compare the two, there are some things that are quite nuanced. But basically, anytime you're going to start collecting personal information, you want to double check, is this compliant with GDPR or CCPA regulations? And really, there are 6 ways of legally storing data under the GDPR. And the first one is the consent. So once you have that consent, you are able to store that data. But there are other ways. If you have a contract, a performance contract, I listed them because I thought that we want to keep a bigger picture of what's going on as well. If you have a members site or a version of your digital platform that is access limited, that you could have a contract in place that says that, we're going to have your name, we're going to have your personal data, and we're going to use that to give you certain data, certain content. So you could have a contract in place. There could be some legitimate interest or maybe vital interest with health, or some legal requirements with government or any public interest. So there are other things, obviously, in those other 5 cases. Please go to Greg and get the great legal advice. Otherwise, keep to getting your consent. That's the best way. A little note here on collecting data. We all probably have experience with some forms, and you need to be granular. In other words, I can have here a small form. I have to agree to, so I have to opt into that before I send my message. If I were to add, do you want to also subscribe to our mailing list? I have to also have, that has to be properly opt in. So I would have multiple, potentially multiple moments where the user has to agree each time to what you're doing. And at all times, you must have a link to your privacy policy that is expressing how the user can opt out, how the user has that right to delete. And these are, unfortunately, little things that anybody can do. It's really quite easy, but are often put aside because it's a bit time consuming. But they really are simple now to do. Everybody should have their privacy policy up to date at this point. So what about analytics and anonymity? Because that has always been, since the GDPR came out, a threat to marketing campaigns, a threat to customers just trying to understand where users are coming from. So this is just a common basic graph. In orange was the previous year's traffic. In blue, this year's traffic, or at the time 2018, and we can see, and then 2019, and we can see when the banner ad was put in place. Up, we see a good chunk of traffic was lost. Actually, the curve should be going up in blue, as it was going historically, but the banner ad knocked out. It's hard to get a statistic today, but word is that easily 40% is lost in that traffic. But the good news is there is something we can do with anonymous tracking. I won't go into too much detail, but some of you may know Matomo, which proposes to anonymize up to 3 levels of the IP address. Basically, the IP address is a locator, and the first locator is fairly universal, whereas we'll get lowered down the number. We can get to the, pretty much to the building, at least to the city. But Google also, you can, and it's not something that's actually widely known, but if you put in place with Google Tag Manager, linked to your Google Analytics, you can actually anonymize the IP addresses. And they remove the one last digit, and that might be a question I would send to Greg, is that enough? The last digit basically represents the city. So some of the consequences are some city data might be skewed, and so obviously you want to do some tests before you do this, but the experience is that it is GDPR compliant. It does allow instantly, when somebody comes on the website, the cookie is active. So you are back to getting the full field of traffic that is coming to your website. So this is something we recommend. And the only thing is that when no, lost it. So, and then what you want to do is use the Search Console for performance measure. So we want to combine the different tools. And basically, once you start anonymizing, Greg touched on that, if you anonymize the traffic, the data, it's no longer a GDPR issue. And also recognize that this is not actually about you. If you're a company in France and you have analytics going on, the problem is not you having access to that traffic. The problem is what Google is doing, because that information is going to the United States, and what are they doing with that information? But in this specific configuration, Google is anonymizing it up front. On advertising, very quickly, using any kind of Facebook pixels, Google ads, or anything, it's even more important that you get consent and you have your privacy policy up to date. These are very notorious usage of data and data issues. And right now, the CNIL is really cracking down on these types of instances, and that can trickle down to small users. They're looking at all these third-party cookies, and they're looking at this data that's being collected through advertising, because I mean, we're all faced with a lot of spam, with a lot of issues. And so data is just becoming too accessible. So that's why the GDPR is there, really to protect the user. A couple more things and then I'll be done. The right to delete. This is kind of interesting because this doesn't happen very often, but there might come a time when somebody wants to be removed from your data and you need to be ready. Today, it's a very simple procedure. They need to download you can have a PDF file accessible on your site that they need to sign. They can send it by slow mail or email, and they have to obviously give some identification. You have to check. It can be quite a process, but you have to give them that right, and especially if you're using data massively, you want to make sure that people have that option. Offboarding, a little digression here, but I sort of feel that this is very similar, is that if you want to cancel your account, especially on the big services that I mentioned here, Google, Facebook, Apple, it can be quite complicated to cancel your account. So if you have a big service such as them, well, congratulations, but make sure that users can cancel their account very quickly. And there have been studies on this where it can take up to 10, 12 minutes to cancel an account. That's probably not too bad, but it should be very quick and painless. And lastly, your privacy policy, please have that up to date. A politique de confidentialité in French. So who is responsible for the treatment of the data? What is actually happening to the finality of that data, including your third-party cookies? So if you explore some of the privacy data policies out there, you will see that a lot of these companies that are using data really thoroughly mention each cookie that's there, what it's doing, and why is it useful for the user. There is always that, why is it useful for the user? That allows the user to say, okay, I don't mind. And make sure to mention the rights that users have in accessing their data, and to remind them that the type of data that is being collected. Thank you. So, Nick, I send it back to you.
Actually, Alex,
Greg?
if you don't mind, I'd like to just make a couple comments following your great presentation,
Okay.
where I learned a lot, and I'm sure the people watching this have learned a lot as well.
Great.
I just want to mention that when we talk about cookies, we're talking not just about the GDPR, but we're also talking about another piece of European Union legislation called the e-privacy directive. And that was amended by a European directive in 2009, became implemented in France in 2011. And that amendment was often referred to as the cookie directive. And so that really placed these requirements of consent for placing a cookie on equipment. And that legislation applies even if the person placing the cookie is outside of the European Union. Because the real test for the territorial scope of that provision is that the cookie is being placed on the equipment of someone in the EU. In other words, it could be placed on a smartphone, it could be placed on a tablet, could be placed on a computer, but that equipment, if it's located in the European Union, that's enough for the European Union e-privacy directive to apply. Okay. Now, in parentheses, I just mentioned that the e-privacy directive is going through a potential modernization to create what would be called the e-privacy, referred to as the e-privacy regulation, applicable in the same form throughout the European Union. I just saw a new draft come out this month. Yeah. So it's currently being discussed in the European lawmaking institutions, the Council and the Parliament. I don't know what it's going to look like in the end, but it may involve discussing common settings for cookies when you configure your browser. But
that is happening, yes, indeed.
Yeah, I don't know what it's going to look like until the legislation's adopted.
And some navigators are actually working on it with or without legislation, but that's another topic.
Now, let me mention another thing. When you talked about the tracking walls or the cookie walls, this is related to the concepts of the requirements for consent under the GDPR.
Yeah.
And one of the elements of the GDPR's conditions for proper consent is that consent must be freely given. And if you're using a cookie wall or a tracking wall to block entrance into the content, well, you're really forcing someone to accept those cookies in order to have access to the content, unless you have some alternative way for them to get in. Maybe less content available, but they can still get in without accepting cookies. Maybe paying a fee or so on. But there's got to be a way for them to get to that content without forcing them to have the cookies placed on their equipment.
Exactly.
So that's something I wanted to mention. Now, you mentioned GDPR storing data. You had 6 items. Those correspond to what I mentioned as the legal or legitimate bases for processing data. So we're completely together on that. We may refer to it a little differently, but that's the same thing. Secondly, next on this question of anonymization, anonymization, once it's properly done, and some of the criteria that the supervisory authorities in Europe will look to is what is possible what's available in terms of technology today, how much does it cost, what is the time involved to re-identify, and so on. When you gave me the example, taking off those last 2 digits, well, I read that as a possible 99 IP addresses. Can we cross that with other data to re-identify the person? So that easily re-identify the person. So that's something you have to think about.
Yeah.
To see if it's properly anonymized. And when we talk about anonymization, we have to keep in mind that if you collect the data before it's anonymized, anything that happens to it before the anonymization still has to comply with the GDPR. And the purpose you specify would have to say something about anonymization, because going through that anonymization process is a kind of processing itself. Processing, like the definition of personal data, is a very broad concept. It can include most anything you do with data.
Yeah.
So I think those are the points I wanted to make, but I thought your presentation was great, very practical. I learned things, and if anyone out there has questions, we're ready. Nick will read the chat box and read us those questions.
Well, yes, I did get some questions, some ahead of time. Is there an easy way to check our compliance on a website?
Actually, there are some tools out there. You should check your compliance. There is something like a cookie bot. These are third-party services that you can use, and it will, in some cases, for free, check a couple pages. For a paid amount, can check your whole website. But basically, it's going to give you a report on all the cookies you have on your website that you might not even be aware of in some cases, because if you're a company owner and you've outsourced the job, you don't always have that information. And it'll tell you basically that this cookie is not compliant, and what it's doing, where is the data going, if it's going, especially if it's going to America or outside the European Union. And so you can check your compliance. You should check your compliance regularly. And of course, the third party issue is actually something, like I said, the CNIL is going to be cracking down on that. And I think that this may trickle down to small businesses as well, inadvertently, but nevertheless, you're required to know that. So yeah, there are tools out there. CookieBot is one. You can look it up on Google.
If I could add something, I think you should check regularly the supervisory authority websites like the CNIL in France, because they may have tools available. And secondly, maybe I can give a plug. There's some researchers out there at the INRIA in France who are doing lots of research about compliance and cookies. In fact, in the few minutes before our webinar today, I was looking at a new paper they have on legal requirement, dark patterns and legal requirements of consent banners, which fit exactly into what Alex was telling us about the cookie banners.
Yeah.
So they're doing some great work, and I think they may have created a tool too. So there are things out there that you can use that can help study this compliance.
Great.
Okay. I have a question for you, Greg. Do you think we are, this comes from somebody, do you think we are moving toward greater data localization requirements globally?
Well, actually, it's good that you mentioned this. I talked about the Schrems II decision, and many people, and probably myself included, think that companies will find it easier to localize their data in Europe than to meet some of the requirements that the Schrems II decision placed on transferring data to the United States because of the access of the US authorities to the data in the United States. So that may be one practical result of the Schrems II decision. But on another level, we're seeing already nation states adopting data localization requirements, like China, like Russia, for example, keeping your databases in China, for example. So I think we are going to probably see more push on data localization, creating what I think it is the Economist called, or maybe it was the Financial Times called, the splinter net, splintering out the internet a bit. So yes, I think this is probably something we're going to see more in the future.
Well, I would add too, I mean, I see more countries. I'm in Vietnam right now, and they are also looking at what they can do for data privacy. But in the United States, it's every state for themselves, Greg, and California got the ball rolling. You talked about Washington. Do you think each state is it going to be very heterogeneous, or do you think the federal government will step in?
Okay, this is an interesting question, Alex. In fact, I wrote something on it, and I said I see 3 barriers to having similar data protection legislation in the United States to what exists in Europe. And those barriers included some of the action of the tech giants themselves in lobbying to defeat some propositions. And also we have a different legal culture between Europe and the United States, where there are things like the emphasis on the freedom of speech, which might mean you wouldn't have the right to delete like you could have in Europe for data. So I don't see today a complete harmonization coming around the track. I see outside of the United States, I see countries using Europe's legislation as a model. And I see even some states, like the Washington state, when I looked at their proposed bill earlier this year, they specifically referred to the GDPR as an influence on the Washington thing. Now, the question is going to be, if we have enough diverse US state bills, will that be enough to push the government to do something? And what we call in legal language, preempt the state legislation, so that the federal legislation becomes the applicable legislation in terms of data privacy. Today, I don't see that happening, but we'll have to see what's going on. But this makes it difficult because small companies that you're referring to, if they meet the thresholds of transactions in California, they have to respect the California law, which has got some similarities to the GDPR, but isn't exactly the same. So this increases compliance costs. That's true.
Thank you. Any more questions? Maybe.
Yeah, there is one question from one person. If I anonymize the IP address with Google Tag Manager, what are the potential consequences to the statistics? Will I lose certain data?
Yeah, so I had mentioned one of them was that they, in the tests that were done, the city with the last IP, so it's, Greg also touched on that, you know, is it enough that you can put together other points to find out where that person is? But basically on your analytics, if you do the anonymized IP, you might have some data that is not 100% accurate in terms of city location That's the only consequence that we've been able to find so far. Other than that, it does give you the full breadth of all the traffic that's coming to your website. And so we're currently applying that with our customers.
Okay. Okay. So just to be clear on the Matomo, you talked about 3 levels, and then you talked about Google Tag Manager removing 1 level. What happens if you use Matomo? Are you able to remove the cookie consent banner in that case, or in both cases, or does it depend on the other third parties as well?
If you anonymize your data, so if you use Matomo, and there will be a cookie, but this cookie is not intrusive. It doesn't store any data. By default, it takes out two points, 2 of the digits, and that is considered by Matomo a good way of being compliant. So basically, you would not have to have any banner ad. You might have other cookies, but as far as statistics is concerned, you no longer need the user consent. Go back to what Greg said. If that is properly anonymized, then you're not under any GDPR rules, basically. Okay. So Matomo is actually a big player. In our case, we often put Matomo and Google Analytics on sites to compare data.
Okay.
That's all.
All right. There's one person wanted clarification. I think this is a question for Greg. What is the difference between personal data, the term used in Europe, and personal information or personally identifiable information, the term used in the US?
Okay, the 2 terms are in some ways similar but different. And that is, I think we could say that the European term, personal data, is much broader than the US term. Usually, if we use the term PII, personally identifiable information, normally the person has to be identified. Whereas the European term, there has to be a way that they can be identified. They don't have to it's not like it has to be their name or their telephone number. There has to be some way. And I think one of the differences, one way I can illustrate this, is in the area of IP addresses, where in the European Union, we've got a couple cases where it's been found that even randomly issued, what we call in French, aléatoire IP addresses can be personal data if there's a way, a means of legally obtaining it, maybe through an internet service provider, of making that link to the person behind the data. Whereas in the United States, there have been some court cases that have been kind of split on whether or not IP addresses will be considered personal information. The way a person walks, what we call the gait, maybe a form of personal data. An avatar created by a person, maybe their personal data, and so on. But I'll do a plug for my writing. I discuss this in depth in one of my articles. And my articles, I try to make them available to the extent possible legally through open access on the internet. So I've got one article called Personal Data and the GDPR. It's co-written, Personal Data and the GDPR, Providing a Competitive Advantage for US Companies, which appeared in the American Business Law Journal. And there's a preprint that's available in open access. But to get the final version of that article, you have to access it either through a database or by purchasing access to that article. So that's my plug for my writing. But if you look in a search engine and type my name, you'll find a lot of my writings available. Or even look at TBS Business School's website. You'll find a list of my publications in the faculty directory under my CV.
Right. So as we mentioned at the beginning, this webinar is recorded. We'll put it online at some point. I don't have any further questions unless you guys wanted to bring something up, or Alex, do you have?
It's been good to be here. I hope it's been useful. And with the EACC, I would definitely want to say that we're looking to put out more webinars, and really appreciated having Greg come on board with his expertise.
You're very welcome.
So I think it's a good time to sign off and go to bed.
Well, thanks to the participants as well. Thank you for joining us, and feel free to follow up with Greg or Alex with any questions. You know, they're good guys to know.
Thank you, Nick.
Thank you very much, and thank you and the public for your attention.